the person filling out the reasonable impediment provision doesn't lie, the ballot counts. The General Assembly also sought to ensure that the people of North Carolina were educated about SB 824. The General Assembly charged the State Board of Elections with identifying voters who may lack North Carolina DMV ID and informing them about the law. It directed the State Board to include in all voter education materials sent to citizens and on informational posters at polling places a statement that, quote, all registered voters will be allowed to vote with or without a photo ID card, close quote. And the State Board was also required by the General Assembly to send not one, not two, not three, 4 separate mailings to every household in the state over the years 2019 and 2020, describing the forms of acceptable photo ID and the options for provisional balloting for those who lacked a photo ID. You don't have to take our word for it, Your Honors. The nonpartisan National Conference of State Legislature classifies the law as, quote, non-strict, close quote. And Professor Keegan Callanan of Middlebury College, who's currently teaching at Princeton, will testify that the General Assembly crafted a non-strict, flexible, and accommodating law as compared to other photo ID laws. And that conclusion is obvious given the sweeping and generous nature of the reasonable impediment provisions. Plaintiffs have no answer to this expansive nature of the law. Why would a legislature that was racially motivated include as qualifying IDs held by college student and governmental employees who are disproportionately minority? Why would a racially motivated legislature create a reasonable impediment provision that allows everyone to vote with or without an ID, provided they tell the truth? Why would a racially motivated legislature look at 184 reasonable impediment ballots cast out of over 2 million people voting and look at that and say, let's make the law more lenient so that there are fewer reasonable impediment ballots that aren't counted, and would consider that a tool of political entrenchment? Why would a racially motivated ID make IDs free with no documentation? And why would they make them available at one-stop voting to eliminate the marginal burden of transportation? And why would they make 4 voter mailings to every household in the state? The answer is a racially motivated legislature would not have done any of these things, let alone all of them. And they have no answer to that point. Because no racist legislature, no racially motivated legislature would ever have enacted this law, they tried to divert the court's attention to a different law, to HB 589, the omnibus election law that included a voter ID provision and was struck down by the Fourth Circuit. But there are numerous dispositive distinctions between SB 824 and HB 589. First, the current law implements a constitutional amendment. We don't have to speculate about why they adopted it. They were required to. It is a standalone bill. It's not part of an omnibus piece of legislation. It had an African-American Democratic primary sponsor. One of its primary sponsors was an African-American Democrat, and it obtained votes from other African-American members of the legislature and other Democratic members of the legislature. And that's far more noteworthy than the idea that there was some overlap between and that the legislature hadn't totally flipped over in terms of its composition from 2013 to the enactment of SB 824. It's no wonder that the Fourth Circuit, with a panel of judges appointed by President Trump and President Obama, stated that, quote, nothing here suggests that the General Assembly used racial voting data to disproportionately target minority voters with surgical precision, close quote. And when the Fourth Circuit made that statement that nothing before them upheld that proposition, they had the expert report of Professor Lilodis before them, an expert report by that same witness. Against this backdrop, plaintiffs have a heavy burden, really an insurmountable burden, in attempting to prove the General Assembly enacted SB 824 to discriminate against African Americans, and the Arlington Heights factors demonstrate why they fail. Let's start with legislative history. That legislative history demonstrates that this law was not passed to discriminate against African Americans. It's important to bear in mind the plaintiff's theory of racial discrimination. You heard Ms. Riggs disclaim racial animus. That's not their theory. Their theory is that Republicans targeted African American voters to entrench themselves. That's their theory. And it's completely implausible because the law doesn't prevent people from voting. What sort of person, what sort of legislature would say, well, I want to entrench myself, so I'm going to pass a law that allows people to continue to vote with or without an ID? It doesn't make any sense. And if we look at the legislative history, as I've noted, there was support from African Americans and Democrats, which again suggests that their theory doesn't make any sense. You'll hear testimony from Joel Ford, one of the bill's 3 primary sponsors, who is an African American Democrat. In addition to Joel Ford, another African American Democrat, Don Davis, and 2 white Democrats, Dwayne Hall and Ken Goodman, also voted for SB 824 in its final form. And a third African American Democrat, Ben Clark, voted for SB 824 the first time it was in the Senate. You won't see this support from Democrats, from African American Democrats, if SB 824 really were weaponized for political entrenchment of the opposing party. Other facts of the legislative history disprove any allegation of racial discrimination. The first draft was publicly unveiled on November 26, 2018. And there was a meeting where Kim Strzok, who was the then executive director of the State Board of Elections, gave a presentation about the implementation of 589, because 589 had been in place for the primary in March of 2016. And she said that there were 2.7 million votes that were cast, and that there were 1,048 people who cast reasonable impediment ballots. 864 of those were counted, and as Ms. Riggs did the math earlier, 184 reasonable impediment ballots were not counted. That's 0.01% of those who were trying to vote. But rather than be content with this small number, the General Assembly actively enacted in SB 824 a wide number of changes to drive that number lower. It expanded the list of qualifying IDs. It created the free no documentation, one-stop early voting option. It lowered the age to obtain the free ID from 70 to 17, and it later added public assistance IDs. The evidence will show that these changes alone should substantially reduce the number of people who cast a reasonable impediment ballot and who need to cast one. Of the 184 reasonable impediment ballots that were not counted in 2016, it should be noted that 80 of them were cast at one-stop voting. Presumably, it would have been easy saying, go over there, get your free ID with no documentation. And those 80 would have been taken off the table. 50 of them were at Duke, and Duke's student IDs have now been approved. The General Assembly also adjusted the reasonable impediment process to make it more protective of voters. 3 changes are particularly noteworthy. One, under 589, voters could fill out a reasonable impediment form if they had an impediment to obtaining an ID. But under 824, you can fill out the form if you have an impediment for presenting the ID. That's important because if you have it, but you've left it at home, you didn't have an impediment obtaining it, you just forgot it. So you have, it's more generous and forgiving. And that's true. And if we look at the reasonable impediments that weren't counted in the 184, 15 of them were people who had IDs and had simply forgotten them. Second, under 589, voters had to present documentation or provide their date of birth and the last 4 digits of their social security numbers. 73 of the 184 reasonable ballots were reasonable impediment ballots were rejected because people did not have the last 4 digits of their social security number. And that is no longer a requirement under SB 824. And third, under 589, a reasonable impediment ballot could be rejected if it made nonsensical or degrading, disparaging remarks about the requirement. That's no longer a basis for rejecting a reasonable impediment ballot. Only falsity is. Another important aspect of the legislative history is the degree to which the Republican Party worked collaboratively with the Democratic majority in crafting SB 824. The legislative record indicates that between the time a draft bill was first circulated and the second reading in the Senate, there were 24 changes that were made to the bill based on discussions with Democrats and other interested parties. In addition to these 24 changes, Democrats proposed 13 non-withdrawn amendments, and 7 of them were enacted. Now, what's remarkable about this bipartisanship is the Republicans had a supermajority. They did not need a single Democratic vote. They did not need any input whatsoever from Democrats. They could have just crammed this through without any of the 24 changes, without any of the 7 amendments, without any Democratic primary sponsors, and they would have had a law, and they didn't do that. Instead, they extended their hand across the aisle and worked with Democrats. And again, don't take my word for it. I want to read to you what the legislative history you're going to hear shows. It's first Democratic Senator McKissick said, quote, "I'd just like to say thank you to Senator Daniel and Senator Quarick for their work on the bill and for being open and inclusive in listening to us on the other side of the aisle and trying to come up with something that is reasonable in terms of its approach. So I want to say thank you for that effort." Democratic Senator Smith said, quote, "I want to thank the bill's sponsors for the hard work that you have been doing in negotiating and accepting many of the amendments that have been placed before you." Democratic Senator Van Doyen said, quote, "I want to very sincerely acknowledge the work that Senator Daniel and Senator Quarick did, particularly around amendments that have been brought to you by my colleagues, my Democratic colleagues. I'm very grateful for everyone that you've incorporated." Senator Woodward, quote, "We appreciate the Republican caucus amending the bill to allow issuance of voter IDs during early voting. And we appreciate the dialogue and the 34 changes that Senator Quarick cited." It wasn't just senators. Democratic Representative Harrison, quote, "I did want to start by thanking Chairman Lewis because I think he's done a really terrific job working with us to help improve the bill. And this bill is a much better bill than the bill that left this chamber in 2013. So I want to thank him for that," close quote. Democrats wouldn't have been thanking Republicans like this if this were a law that had been weaponized against them to entrench their political power. Let's look at the specific sequence of events that led to the passage of SB 824. Plaintiffs have identified no procedural irregularities. They're going to call Sabra Affairs, who you've heard worked in the North Carolina General Assembly. But this was not an aberrational process. This was the first time in North Carolina history that a supermajority, a veto-proof majority, was losing that status, and a governor of the opposite party was coming into power. And so there was nothing aberrational about this, and she certainly can't speak to what's aberrational or not in other states. She has no experience whatsoever with legislative processes in other states, but Professor Callanan does have that expertise. And he will testify that it was fully consistent in this sort of situation where one party is losing its power to act in the fashion that SB 824 was enacted. And the only thing that would have been abnormal is if they had just waited so that Governor Cooper could come in and veto all of their efforts. Now, really the centerpiece of the plaintiff's case is whether the law bears more heavily on one race rather than another. And as I've said several times now, their theory is Republicans were entrenching themselves by targeting African American voters. Now, for this theory to make sense, you need to prevent the voters who supported your political opponents from voting, and that's not what we have here. We have a law that allows everyone to vote, with or without a photo ID. Now, they point to an alleged disparate rate of ID possession. But this will not translate into political entrenchment given the reasonable impediment provisions. And it's particularly true given that there's a free, no documentation ID available during early voting. In addition, you're going to hear from Professor Trey Hood, who's a professor of political science. He has published a peer-reviewed article on the effects of similar, though not as generous, voter ID law in South Carolina, and he found that there was no impact on African American turnout, no disproportionate impact in South Carolina. South Carolina is important too because their law was pre-cleared by a federal district court, and as the court knows, the court found that South Carolina's reasonable impediment provision eliminated any disproportionate effect or material burden that South Carolina's voter ID law might otherwise have had. And here, the reasonable impediment provision is even more sweeping and generous than South Carolina's. But even putting aside the conceptual point that you're not going to entrench yourselves and the legally relevant effect should be the impact on voting, let's look at what they say about ID possession rates. They have a matching analysis from Professor Kevin Quinn, who's going to look at North Carolina voter registration and certain ID databases. But of course, Professor Quinn's analysis wasn't before the General Assembly, and the General Assembly had reason to be very skeptical of this type of analysis. In the November 26th, 2018 Kim Strock presentation that I referenced earlier, she talked about how the state board had sent mailings out to 400,000 people who were on the no match list under 589. 86% of those responded said, I have an ID. 86%. That's not disputed. Of those who responded said, I have an ID. So that gives you a sense how wildly over-inclusive this no match list is. Also, as I indicated, there were 2.7 million people who voted in the March 2016 primary. Only 2,296 lacked an ID, so that is less than 0.1%, a far cry from the 7% that Professor Quinn indicates. And it shows, the actual experience shows that these no match analyses vastly overstate the actual lack of IDs. Quinn's analysis suffers from a myriad of flaws which have come out in cross-examination, but just to highlight a couple of the big ones, he doesn't even have access to list of all the qualifying IDs, passports, military IDs, veteran IDs, tribal IDs, public assistance IDs. He doesn't have that information. So when he comes into court and says, well, it's 93%, that's on just a partial showing of some of the IDs. And he only had incomplete IDs for students and governments. So his is a necessarily incomplete analysis. To give you a sense of the dimension of this, in 589, there was state litigation. It was called Curry. And in that litigation, Professor Quinn was able to get the passport information from the US government. And it showed that when he got that passport information, the non-match list went down by 160,000 people. And so that shows, and he wasn't able to do that analysis here, and we're not criticizing him. He didn't have access to it. The federal government didn't give it, but he didn't do the analysis. And that shows that there are at least tens of thousands, if not 160,000 people who are improperly included in his match list. He attempted to control for this data by looking at a survey of people who have passports, but number one, it wasn't a representative survey of everyone in North Carolina, and it certainly wasn't a representative survey of, and didn't even purport to answer the question, which he admitted is the relevant question, which is, of those in North Carolina who don't have one of the other qualifying IDs, how many have passports, and what is the racial composition of that? So there are a lot of glaring holes in the Quinn analysis, but if we take it on face value, I'd like my colleague, Ms. Hardiman, to put LX 171 on the screen. And we can see his Quinn's analysis, and maybe we can blow that up just a little bit if it's possible. It's fine either way. His findings support the conclusion that the General Assembly substantially narrowed any racial gap in ID that existed under the prior law. So under the prior law, if you look in the, I guess it would be the first column, well, you start in the left-hand column, it says African Americans, then you have the column of Curry, and it says 9.6%. And then for the whites who are lacking IDs, it's 4.46%. So that's about a 5 percentage point difference under 589. Under their analysis, which is overstated, SB 824, African Americans lack these IDs by 7.61% and whites by 5.47%. So it's shrunk to 2.5%. In other words, the difference between whites and African American possession rates under their analysis fell by half based on the new law. And his analysis, Quinn has very little data on the free IDs, the new, no documentation free IDs. But the little data that he has suggests that 41% that were issued before preliminary injunctions issued, 41% went to African Americans, who represent 22% of the population. What about voters who voted in 2016 and 2018? And if we look at this chart, you can see what they're trying to say. They're saying, look, on average, whites have 95 out of 100 whites have these IDs. And on average, they're saying, if you look at this chart under SB 824, the upper right-hand corner, approximately 7% of African Americans don't. So they say, well, that's a difference of 2%, and over the 5% difference, that's a 40% differential. That's where they get their 39%. I'm rounding a little bit. But the other way to look at that is to say, well, 95% of the whites have these and 93% of the African Americans. And if you take 93 and you divide it by 95, then you see that African Americans are 98% as likely to have the IDs. This is a sleight of hand. I mean, just to understand what they're doing, if there were 3 people in the state of North Carolina who were affected by this law, one of whom was white and 2 of whom were African American, they'd be in this court saying that the rate was twice, 100% higher for African Americans. Don't be fooled by the statistical sleight of hand. Let's look at the historical background, and we acknowledge the deeply lamentable and indeed shameful history of racial discrimination in this state. But SB 824 is not part of that shameful history. It is a state-of-the-art, voter ID law that both seeks to secure elections and to guarantee access to all registered voters. It's even more accessible to the ballot and has more access to the ballot than the recommendations by the commission co-chaired by President Jimmy Carter. President Carter has spent decades as a champion of voting rights. His report recommended the adoption of voter ID laws, which after a grace period required photo IDs with no reasonable impediment provisions whatsoever. There's a reason North Carolina's law has been graded as non-strict by the National Conference of State Legislatures. And as I've noted, one of its primary sponsors was a Democrat, African-American Democrat, and two other African-American Democrats voted for it at various stages in the legislative process. We've been told that we'll hear from Professor Lillotis and Anderson, and we don't agree with everything they say, but again, we don't dispute that North Carolina's history has been marred, shamefully, by historical acts of discrimination. But it is well established that past discrimination cannot, in the manner of original sin, condemn governmental action that is not itself unlawful. And putting that principle into effect, courts have rejected racially discriminatory challenges to voter ID laws in Alabama, Virginia, and South Carolina, among other states. Indeed, it's important to note that before Shelby County, Alabama, Virginia, and South Carolina were all covered jurisdictions under Section 5 of the Voting Rights Act. That meant they bore the burden of proving that their laws had neither a discriminatory purpose nor a discriminatory effect. If there had been any discriminatory effect, unless they could eliminate that possibility in the minds of the courts, that there was any discriminatory effect, none of those laws would have been pre-cleared. And yet they were. And as I referenced earlier, the reason South Carolina's was approved by the courts and found not to have any discriminatory effect was because of the reasonable impediment provision. As for their experts, Professor Lillotis, obviously his analysis did not move the Fourth Circuit Court of Appeals. Professor Anderson has incredibly acknowledged she did not review the text of SB 824. She was unaware that one of the primary sponsors was an African-American and Democrat. And when she was confronted with that fact at her deposition, she said that African-Americans as well as whites can act out of white rage. That's what her term is. There was reference made to the North Carolina Court of Appeals decision, and it's important to recognize that the Court of Appeals itself has been explicit that an interlocutory ruling is not, quote, binding at trial on the merits, close quote. That's the Precision Walls case. And we recommend the Fourth Circuit's decision, very comprehensive decision, as one that is entitled to be taken into consideration. But even taking the North Carolina Court of Appeals decisions at face value, it doesn't support the plaintiff's case because the record is substantially different. And there are two differences I'll just touch on in my waning moments here. First, the General Assembly has amended SB 824 to include public assistance IDs. And the lack of public assistance IDs was a key foundation of the Court of Appeals decision. Second, the Court of Appeals relied on Professor Quinn's preliminary injunction report, in which he had opined that, quote, given the data available to me now, my expert opinion is that the rates of photo ID possession by race and inactive status that I documented in my 2015 report remain accurate estimates of the corresponding rates of photo ID possession in 2019. But as we just showed you in LX 171, Quinn's new matching analysis shows that the disparity that he claims, and we say is way overstated, but he, by his own analysis, shows that it's shrunk in half. And that's without factoring any of the new IDs that have been included that are going to shrink it even further. So this pillar of the Court of Appeals decision has been removed. For these reasons, Your Honors, we submit that the plaintiffs will fail in their effort to try to persuade this court that SB 824 was a weaponized voter ID law intended to entrench Republican interest by targeting surgically African American voters. Thank you, and I'll turn over the balance of my time to my friend, Mr. Cox.
Thank you. Good morning, Judge Poovey, Judge Rozier, and Judge Ofalu. I'm Paul Cox from the North Carolina Department of Justice, and on behalf of the defendants, the state of North Carolina and the North Carolina State Board of Elections. As Mr. Thompson has indicated, we have worked out an understanding with the legislative defendants whereby the legislative defendants will conduct the bulk of the presentation on behalf of the defense, because the sole remaining claim in this case is that the legislature engaged in intentional discrimination when it enacted SB 824, and the legislative defendants are parties to this action. They're appropriately equipped to mount a defense as to the motivations of the legislature enacting the law. So with respect to judicial economy, the state defendants will not retread all of the evidence and legal arguments pertaining to the Arlington Heights test, which is the multi-factor standard for judging intentional discrimination. We will instead supplement the defense with evidence and argument that is particularly within the state board's purview. Namely, we will present on how to interpret the provisions of SB 824 from the perspective of election administrators, and how the State Board of Elections is committed to and is capable of implementing those provisions in a non-discriminatory way. On the first point, what the legislature wrote into the law is probative on the question of its motivations. SB 824, as enacted, carries out the requirement that in the North Carolina Constitution, quote, voters offering to vote in person shall present photographic identification before voting. That provision required the legislature to enact a law to implement this requirement, which could provide for exceptions. And the result is SB 824. SB 824 provides a list of officially sanctioned photo IDs for voting. You heard Mr. Thompson identify them, so I won't go over them again. I'll just add that with respect to the student IDs and the public employer IDs, the State Board of Elections has approved 118 of those IDs for voting in elections. And you'll see that through the evidence. All of these IDs, when unexpired, are acceptable, of course. The law also permits expired IDs, but the circumstances vary based on ID. Military, veteran, and tribal IDs may be presented even if the card has no expiration or issuance date. If a voter is 65 or older, an expired ID is acceptable as long as it was unexpired on the voter's 65th birthday. And the remaining IDs may be presented if they have been expired for 1 year or less. The evidence will show that the vast majority of North Carolina voters possess one of the acceptable forms of ID. Of course, the evidence will also show that some North Carolinians do not possess an ID as just described, or perhaps they will have lost that ID or forgotten it when it comes time to vote. The law still permits these individuals to vote, but by three different mechanisms. First, free IDs, two, broad exceptions to presenting ID in person or by absentee voting, and number three, voting provisionally and then returning to the county board with your ID. First, voters without one of these IDs can obtain an ID for free and no cost from the DMV or the County Board of Elections. With respect to the Elections Board ID, voters need not present any documentation. They just provide their name, date of birth, and the last four digits of their social security number. As Mr. Thompson has said, that these IDs are available from the County Board of Elections up until the last day of early voting, typically the Saturday before Election Day in North Carolina. Now, for an ID from the DMV, anyone over the age of 17 can get a free non-operator ID any day that the DMV is open. I should also note that the law requires the DMV to automatically send a replacement ID to any North Carolinian whose license is suspended or revoked such that they have to turn their license into the state. Now, second, if a voter still does not have acceptable ID when they go and vote, even if they just forgot it, they can still vote under three exceptions to the ID requirement. Two of them are narrow and one is broad. First, if the voter is a victim of a recent natural disaster. Second, the voter has a religious objection to being photographed. And third, the voter has a reasonable impediment that prevents them from presenting ID when voting. Now, the last provision is the broadest. Reasonable impediments under the law explicitly include a number of obvious ones. The inability to obtain ID because of lack of transportation, disability, illness, lack of documents like birth certificates that you would need to get an ID at the DMV, for example, work schedule, family responsibilities, you've lost or you had your ID stolen, or you've applied for an ID but you've not yet received it. These are the explicit reasonable impediments in the law. But in addition to these, the law also permits a voter to identify any, quote, other reasonable impediment. When claiming one of these exceptions, a voter votes a provisional ballot and fills out an affidavit attesting to their identity and the fact that one of these exceptions applies. If they're claiming a reasonable impediment, they either select one of the impediments that I mentioned is listed in the statute, or they write their own impediment in the blank space for, quote, other reasons. Critically, the law requires that provisional ballots cast under one of these exceptions be counted by the county board, quote, unless the county board has grounds to believe the affidavit is false, unquote. That's straight from the law. Under an administrative rule adopted by the state board, a determination that a reasonable impediment affidavit is false must be agreed upon by all 5 members of the bipartisan county board unanimously. A third and final mechanism that helps ensure that a voter can exercise their right to vote, even if they don't have one of these IDs or forgot it, is it's been called the cure mechanism. It's if the voter simply forgets their ID when they go to vote or they don't have an ID, they can cast a provisional ballot and then later return to the county board with an acceptable form of ID. They have to do that before the day of canvass, which is typically 10 days after election day. So it makes it a deadline of 9 days, essentially, after election day. These ID requirements and their exceptions apply largely the same way to absentee voters. Those voters are asked to include a photocopy of their ID in their absentee ballot return envelope, and they're subject to all the exceptions that I've already discussed, including the reasonable impediment exception, and that includes an explicit exception for absentee voters for not having access to a means of copying your ID, for example. And so they would fill out a similar affidavit as an in-person voter and send that in with their absentee ballot. Because voters without acceptable ID would have the option of casting a provisional ballot and having that ballot counted via the reasonable impediment affidavit or later returning with their ID, you'll learn that the nonpartisan National Conference of State Legislatures categorizes SB 824 as, quote, non-strict, in contrast to laws operating in other states that it categorizes as, quote, strict. Lastly, it should go without saying that the state board and the 100 county boards of elections are fully committed to implementing this law in an even-handed manner. They're also committed to ensuring that all eligible voters are able to cast their ballots. And you'll hear that the deposition testimony of the state board's executive director to that effect. The evidence will also show that before the courts enjoined the implementation of SB 824, the state board was well on its way to implement the law. It had, among other things, created materials educating the public about the photo ID requirement, sent postcards about the requirement to voters who the state identified as potentially lacking DMV-issued ID. You'll hear about that no-match analysis later. Sent mailers to all North Carolina households about the photo ID requirement, adopted rules to ensure that the poll workers and county boards were implementing the law in an even-handed manner. They held 2 seminars open to the public in each county to educate voters and community partners about the law. They conducted a statewide training to election officials that included information about implementation of the law, and equipped all county boards with machines to issue free voter IDs and the training to do so. Many other preparations and process enhancements were underway before the injunctions, but these are some of the highlights. Now, the board also has experience from implementing the earlier photo ID law that it can draw from in preparing the public and poll workers for the current law. In other words, the board will not be starting from scratch if this court upholds the law's constitutionality. In sum, we believe the law at issue provides ample means to comply with its provisions. Should this court uphold the law's constitutionality, the state board and the county boards of elections stand ready to implement the law even-handedly and ensure that everyone's right to vote is protected. Thank you, Your Honors.
Thank you. I suppose that right now is a good time to go ahead and break for lunch early. I know, Ms. Riggs, you'd asked for that. And So we would normally break for lunch at 12:30 and come back at 2. Since we're breaking very close to 12 o'clock, we'll just break from 12 o'clock until 1:30. One little housekeeping matter is that I believe one of our judicial fellows by the name of Adam Steele has emailed all counsel a list of documents, or will be emailing them during the lunch break, that will be added to the public website. And so I just wanted to let you know about that. And if you have any issues with those documents being posted on the public website, please get in touch with Mr. Steele. And you can do that at the end of the day during the time that we have reserved for meeting exhibits. With that said, is there anything before we take the lunch recess from anyone?
Nothing, Your Honor. Thank you.
Nothing for the legislative defendants, Your Honor.
Okay, thank you all very much. We'll go ahead and take our lunch recess. We'll start back at 1:30 this afternoon. Thank you.